This is Bloomberg Law with June Grasso from Bloomberg Radio.
It was another transformational term at the Supreme Court where the Republican-appointed supermajority left no doubt that its conservative revolution is pushing ahead to attain its goals without much regard for precedent. The conservatives slashed the power of regulators, ruled that Donald Trump is absolutely immune from criminal prosecution for official presidential acts, made it harder to challenge voting maps as racially gerrymandered, and found that homeless people sleeping on the streets can be jailed. In those decisions, as well as 7 others, the court was divided down ideological lines 6-3, with the liberal justices in the minority. Joining me is Anthony Michael Kreis, a professor at the Georgia State University College of Law. People are bemoaning how the Supreme Court has become so political. But you write that the Supreme Court always has been political and that the court has never been an apolitical arbiter of the Constitution. Tell us why.
So, the Supreme Court has 2 important features in terms of how justices think. I think the first one is that, they're members of society. And so, society has kind of dominant mainstream views and those that are very much on the outside. And justices, much like your average citizen, is going to internalize those views, internalize those changing dynamics in society and current events and all the like. And their jurisprudence is going to sometimes be affected by that. But then the other thing that's even more important in terms of the Supreme Court's jurisprudential outcomes is the fact that it is the byproduct of big political coalitions that elect president and that elect majorities in the Senate that then creates this dynamic where you get a president who appoints justices to the Supreme Court who also reflect their ideological commitments. And so, generally speaking, because of these 2 different features of how justices get picked and how they just operate as regular members of society, right? They're not hermetically sealed off from the rest of us. The courts tend to reflect majoritarian views. Certainly, I think there's a case to be made that this court, the Roberts Court, and as the Roberts Court is currently constituted, a lot of people may say this is well outside of the kind of mainstream views of the average American today. And I think there's an argument to be made for that, for sure. But generally speaking, the Supreme Court, just contrary to what most of us have been taught in law school and in college for years and years and years, it's not a counter-majoritarian institution. It has typically reflected the majority view on major questions of law and politics.
Do you think that this is becoming more pronounced because the court has moved so fast to overrule precedent and to change the law?
Yeah, so I think maybe a good apt comparison may be the Warren Court from the 1950s and 1960s and the current Roberts Court as it's existed, we'll say, since the Trump administration, so around 2016. And certainly there's similar dynamics in that both courts overturned a lot of precedent. People generally don't see the Warren Court as being at a step with the average American's view during that period because the New Deal coalition was dominant and they won outright majorities both in Congress and substantial majorities time and again in terms of sending a president to the White House. And even Republicans who were more conservative than the average Democrat at the time tended to be more liberal. And so the views of the average politician who was electable in that time period was very much in sync with the average view of the typical Supreme Court justice at the time. Why I think people seem more, skeptical of this court is because unlike the Warren Court, for example, Donald Trump, when he was first elected, never cured a popular vote majority. And I think, in terms of public opinion polling, really never cracked a majority of Americans supporting his presidency. And at the same time, there was a dynamic that occurred in the Senate where Donald Trump's Supreme Court nominees, unlike every nominee in years past, was unable to secure a majority of senators to confirm the nomination that he put forward for the Supreme Court, who also represented a majority of Americans because the Senate has become so malapportioned based on population. And so I think part of the anxiety that you see particularly from the center left, and left of the political spectrum here in the United States that is a byproduct of the feeling that the Supreme Court is representing minoritarian on minoritarian on minoritarian interests and not in step with kind of the general flow and trajectory of the American body politic, as was the case perhaps in the 1950s and 1960s. So there are similarities in terms of the court reflecting winning coalitions to a certain extent, both between the Warren Court and the Roberts Court. But I think there are also very significant qualitative differences in terms of where we are in the kind of a longer-term trajectory in American politics.
So let's talk about some of the cases. One of the cases where it seemed to me that politics was blatantly at play was the Idaho abortion case. There were enough justices to place a stay on the district court order so that Idaho could enforce its ban before the decision, but then some of them must have had a change of heart, backed off. And in the dissent, Justice Alito seemed to question why. And is the obvious answer the upcoming election?
I think the answer is it was absolutely the election, and it was a feeling by a number of justices on the court that coming down with a ruling that restricted abortion access further would be electorally damaging to conservatives and Republicans across the country in a very important election cycle. And I think one of the key dynamics here that is important to note is that this was, of course, a dig, right? So it was dismissed as improvidently granted, which basically means that at least one of the members who voted to hear the case in the first place, so voted to hear cert, decided that no, they had cold feet and they just didn't want to touch this. And that to me suggests that, it was probably not one of the liberals, right, who would get cold feet because they would not vote for cert unless they thought they would certainly win, which with this court being as conservative as it is and anti-abortion as it is, that wouldn't be a really safe bet. So it's very likely, if not absolutely certainty, that either Justice Barrett, Chief Justice Roberts, or Justice Kavanaugh were in that group who initially decided to hear this case and realized that it was going to go in a way they didn't particularly like, likely for political reasons, and they backed off. And so I think the court disposition here, at least among the three more, I would say, more moderate conservatives, I wouldn't call them moderates, but they're certainly less conservative than, say, Justice Alito or Justice Thomas. But those three, Kavanaugh, Roberts, Barrett, I think hope that either they could pump this off for another time and decide against the federal government during a year that is not an election year, or they could just sit back and hope Donald Trump wins the presidency in November, wait for the Trump administration to reverse course on this policy that the Biden administration promulgated, and then they won't have to touch it at all. So this was really politics all the way down.
Now, the Eighth Amendment, we don't talk about it all that much in the news and the ban on cruel and unusual punishment. The Supreme Court seems to often ignore its protections, and a lot of times the cases involve criminal laws. But this term there was a case involving homelessness. Tell us about that and what the court did there.
So in a case called City of Grants Pass, the Supreme Court said that it does not violate the Eighth Amendment's ban on cruel and unusual punishment to essentially criminalize people from camping in public spaces. And the hard part here is that, there's a couple of dynamics that really make this situation agonizing, I think, for people who particularly are concerned about unhoused persons and how, we treat homelessness in the United States, which is, a lot of cities create policies and adopt public policies that are not particularly friendly to affordable housing or density, which can make housing more available and cheaper and whatnot, which could help ease some of these pressures. And, cities also seem to be really resistant in many respects to provide adequate services. And so, cities make these deliberate policies which make it harder for people to secure housing or to seek temporary shelter, but then at the same time say, you can't just sleep outside, you can't put up a tent, or we're going to basically criminalize your essential existence as an unhoused person. And so in this respect, the policy choices of cities is really a way to kind of corral people and push them out of their jurisdiction and say, you're someone else's problem now. And that puts people in a really tough bind, and it's really hard to get out. And so, the majority basically said, well, this is not a problem. Like, you essentially have choices here as a person, and that's that. There's no constitutional refuge or shield here under the Eighth Amendment. Whereas I think the dissenters understood the bind that people face in these very tough situations. I think what's telling in some respects, at least for me, as a scholar of political history, and particularly somebody who is focused on Reconstruction, so much of this court is hell-bent on originalist principles. And it's kind of ironic because, if you look back to the 1860s, when the radical Republicans were running the show and Reconstruction was on their mind and the 14th Amendment came into play, as did the forerunner to the 14th Amendment, the Civil Rights Act of 1866. These laws, in many respects, were to push back on southern states which used vagrancy laws, which were very similar, right, to what is at play here in the City of Grants Pass case, and basically trap people either, working on certain plantations or working in certain conditions, kind of fleeing the jurisdiction. And the huge part of the pushback against that was that people should have freedom of movement. And, there were certainly people who also thought that there was a requirement and an obligation on government to provide some kind of basic social safety net. And this is a particularly important point that Reconstruction legislators in South Carolina made in the late 1860s and early 1870s. But there's no originalism here, right? There's kind of no originalism for folks who are poor. And I think that's really kind of telling in some respects about what this court is doing. It's not some kind of neutral jurisprudential decision-making. They make decisions on an ad hoc basis, implementing whatever kind of constitutional tools of interpretation they want as they see fit. There's really no rhyme or reason to it other than they see an issue and they craft a rule based on what they viscerally and politically feel is the right outcome.
Coming up next on the Bloomberg Law Show, what happened to the Chief Justice being an institutionalist who believed in judges only calling balls and strikes? I'm June Grasso, and you're listening to Bloomberg. The Supreme Court's fractured decision in an important gun rights case this term shows the justices can't quite agree on how to use history and tradition to analyze the constitutionality of firearm restrictions. The 8-1 ruling in the Rahimi case, which upheld a federal law that bans people subject to domestic violence restraining orders from possessing a gun, elicited separate writings from 7 of the 9 justices. Concurrences on both sides of the ideological line show there's a rigorous debate going on over the legal theory of originalism, which the court's conservative majority has embraced. I've been talking to Anthony Michael Kreis, a professor at the Georgia State University College of Law. Do you think not only in this case, but in other cases, it sort of exposed the problems with originalism and rifts among the conservatives about originalism? Especially, I think it showed in the Rahimi case, I think, where, what is it? Everyone has a different, not everyone, but there are so many different opinions. What is originalism?
I think the Rahimi case is really telling in some respects. It's ironic to me that Justice Thomas, who wrote the decision a couple years ago in Bruin, which was this revolutionary Second Amendment case, basically was a lone dissenter in Rahimi and said, well, you don't really understand what I wrote. And so, that kind of undercuts the whole point of originalism, right? When you have the author of an opinion that received majority vote by members of the United States Supreme Court saying to other people in the Supreme Court, you don't understand just a couple years later what I actually meant, kind of ironically undercuts originalism and its alleged integrity as a tool of interpretation. But I think the other thing is that it has shown some cracks in that people have understood that originalism, as applied in a very strict and narrow sense, has unworkable and untenable outcomes. And I think, frankly, the fact that the justices all roundly rejected this idea that the Second Amendment should somehow protect domestic abusers and allow them to have weapons, most people in the United States, I think, would say they agree that that should not be the case. But if you applied Justice Thomas's test that he articulated a couple years ago in a truly faithful way, the outcome would have been different. And so I think the Rahimi case, in some respects, illustrates how there's this kind of roving attempt by a number of the members of the court to apply originalism where it works for them and to kind of push back a bit where it doesn't. And that, again, I think truly is astonishing for a group of people who suggest that originalism is the one, only, and true way to interpret the Constitution.
And you point out that there were cases where the court sort of applied lenient statutory interpretations to benefit, for example, the January 6th defendants and white-collar criminals.
Yeah. So to me, one of the interesting cases that the Supreme Court decided was a case dealing with January 6th defendants called Fisher. And in Fisher, there was, again, a kind of this catch-all phrase that if you applied a very strict form of textualism that somebody like Neil Gorsuch would often propose as being his preferred way of statutory interpretation, he should have come out with a different outcome that didn't favor the January 6th defendants. And so I think there are a lot of people, myself included, who may say that that decision in Fisher as a matter of statutory interpretation, it might make sense, it might not. There might be some reasonable disagreement about what that decision should have looked like. But the decision itself pierced kind of the veil of legislative intent and legislative history in order to reach an outcome. And there are a number of justices who sign on to that opinion who generally reject that as an approach to interpreting a statute. And so I think one of the things that is something we should debate, perhaps, is whether or not these justices are being principled or whether they are, again, just kind of approaching these cases like whack-a-mole and hitting the kind of originalist opportunities where they come up and avoiding them where that kind of approach doesn't really work for the outcome that they truly desire. And so I think the real questions that arose out of this term's cases, which really is ripe for debate about whether or not the justices are being true in terms of adhering to this kind of principle or this kind of theory or kind of tool of interpretation uniformly, no matter what the outcome. I think they're often disingenuous in that respect.
So along that line, when Trump was contesting the election in 2020, it seemed like the court didn't do him any favors. But this term, they gave him everything he wanted and more. You mentioned the January 6th case. There was that incredibly broad ruling on presidential immunity. They refused to allow Colorado officials to remove him from the ballot. What happened? Why did they go so far to try to insulate Trump?
I think the big difference is that many people felt in 2020 that President Trump at the time had very weak political standing. There was a sense that there was going to be a total, perhaps, landslide in favor of Joe Biden. And that, of course, didn't really happen. The election was much closer than I think most people anticipated, and that was both of the presidential election, but also in terms of the Senate and in the House of Representatives results as well. But there was a sense that that was probably going to come to pass. And even when it didn't come to pass, at that point, Donald Trump had lost. And so the wind in his sails were completely deflated, and so there really was no benefit to the Supreme Court to go out of their way to help Donald Trump. And if they did, that would have also severely risked their own institutional capital. And that's not true now. Now you have a resurgent Trump. You have an incumbent president who very well may beat Donald Trump, but who seems to be a little weaker than what most incumbents would want to be at this point in the presidential race. And they also don't want to risk the ire of Donald Trump should Donald Trump win the election in November. And so, that's all kind of in that mix. And then, of course, the conservatives are looking out for their own interests, I suspect, which is they would much rather have a 7-2, 8-1, 9-0 conservative Supreme Court if they could have it. And not having a Republican win in November, makes it less likely that there will be more conservatives on the court a few years from now than there are today. So there are a number of different issues that are at play, but I certainly think that some of the change in tone is political. And I also think, though, that some of the key issues, for example, the presidential immunity case, a number of members of this court have truly believed in doctrine that has empowered the executive. They believe in a unitary executive. They believe that the president should have the power to really wrestle control of administrative agencies and change policy as they see fit and things of that nature. And so to the extent, too, that they could write an opinion that is reflective of their very long-standing ideological commitments in consolidating executive power and do so in a way that could at least temporarily, if not long-term, benefit Donald Trump as perhaps their preferred presidential candidate, they're going to do so.
You mentioned the administrative state, basically. And the administrative state took hit after hit from the court this term. And now with its, decisions, it places power in the federal judiciary rather than in experts and agencies. So are we bound to see decisions based on the political views of federal judges more and more, now that they don't have to worry about Chevron deference?
I think it's possible that you could see that. There is, I think, to some extent, a somewhat limiting factor here, which is there will be times perhaps where judges will be a little squeamish of wading into a particular policy and pushing back against it because they just don't have the kind of capacity in terms of technical expertise to do so. There will be other areas, I think this is particularly true in environmental policy perhaps, but there will be other areas where judges will feel a lot more comfortable stepping in and pushing back against the administrative state. But when that does happen and when judges do feel comfortable and more at ease to inquire into the rationality of a particular agency's policy, certainly when you're asking is something rational or, does something kind of pass the sniff test, whatever the test that eventually gets developed, because of course we have a rule from the Loper Bright case, but we don't really know how it's going to be fleshed out over time. I think there is a lot more room perhaps for mischief now where a judge's personal policy preferences will be easily substituted for whatever the administrative agency wants to do. So certainly that is a risk, but I do think that we'll have to wait and see for the next few years how this all shakes out over time.
The Chief Justice, John Roberts, he used to care, or he seemed to care, about the public's view of the court, about the court as an institution, claiming, justices are not politicians, that they're just calling balls and strikes. What do you think happened this term that he seemed to throw away that concern?
That's a good question. I think for a long time, Chief Justice Roberts was dealing with a court that was really straddling an ideological void a bit, where any case could come out 5-4. Really, truly, before Donald Trump took office, the Supreme Court was still incredibly conservative, even though it had a lot more ideological diversity on it. The court was certainly right of center. And when Justice Kennedy left the bench a couple of years into Donald Trump's term, the court went vastly rightward. But I think despite the court's conservative dynamics before the Trump administration, John Roberts still had to cobble together a coalition. And I think that there was a sense that the American public was becoming increasingly liberal, especially on social issues and some of these kind of hot button issues that were very salient during the Obama administration. I think there was a sense that he really had to keep together a coalition of five, and so there might be some internal judicial politics at play there. It's really hard to say, but I think what we can for certain say is that he has seen, for whatever reason, the court, in his view, needs and can take a sharp turn right now. It's hard to understand exactly, I think, without the perspective of more time to kind of grasp exactly what's happened there. But there is, I think, a noticeable shift in the Chief Justice's perspective on the court as an institution and the institutional capital that it has. There are some risks to that. I think that opens up the court to a lot more political attacks, and so we'll have to see if that works out to his benefit in the longer term.
So, as you point out, the conservatives have played a long game with the Supreme Court. So, at this point, what is it that liberals or those in the center can do? Because the court is what the court is, and it's in power, and can anything be done?
I think the lesson for liberals is that there needs to be a long game played in a way that is somewhat similar to what conservatives did in the late 1970s and kind of hypercharged in the early 1980s. Liberals don't have, there's certainly the American Constitution Society, which folks may be familiar with, which is in many respects kind of a liberal version of the Federalist Society, which many people are familiar with. But the Federalist Society is a really powerful organization that began as a small conference at Yale in 1982. A lot of work had to be put in by conservatives and libertarians into that organization to get it in a place where it's kind of at the center of power, right? It took 40 years to be at the true center of power, but it really was a very important institution in terms of developing lawyers into judges and putting people into places of political power and being a truly important center for networking and the spread of ideas that would later become constitutional law. The liberals, I think, need to understand that kind of organizational power, that kind of structural political force is required in order to make the law turn left. So they're going to have to create those organizations or invest in the ones that already exist and understand that that is a long-term investment. At the same time, I think a lot of liberals have been kind of deluded for years by the Warren Court in particular into believing that courts will save us, right? That there's some kind of liberal value in the American constitutional order as embodied by the courts in the 1950s and 1960s that is going to kind of live on in perpetuity. And that's just not the case. Constitutional law begins at the ballot box, and it in particular begins at the ballot box in presidential election years. And so I think for folks who look at the court's conservatism and are kind of struck by it as being bad for the United States or reflecting values that they disagree with, then the response has to be to create the organizations and the kind of structural political forces to push back against that and to invest in electoral politics. And that's really important. Courts don't operate in their kind of independent, isolated sphere. They are truly part of a broader political atmosphere.
Thanks so much for being on the show and sharing your insights about this term. That's Professor Anthony Michael Kreis of the Georgia State University College of Law. Coming up next, the corruption trial of Senator Bob Menendez is coming to a close. This is Bloomberg. In 8 weeks of trial, the government has presented a sprawling case against Democratic Senator Bob Menendez, with testimony from a cooperating witness and more than 1,000 pieces of evidence, including 13 gold bars, $500,000 in cash, and a secret FBI videotape. Federal prosecutors say Menendez put his power up for sale, pursuing bribes for years while promising to use his power to help those who paid him in a clear pattern of corruption. The defense says prosecutors have not come close to meeting their burden of showing the gold or cash was given as a bribe. The 70-year-old senator is accused of bribery, extortion, fraud, conspiracy, obstruction of justice, and acting as a foreign agent of Egypt, and he faces decades in prison if convicted. Joining me from the courthouse is Bloomberg legal reporter David Voreacos, who's been covering the trial. David, tell us about the prosecution's theory of the case.
The prosecution theory is that Senator Robert Menendez engaged in a 5-year bribery scheme with his wife, who was his girlfriend for much of the period, and with 2 New Jersey businessmen who paid him bribes in exchange for official actions. They also say that Menendez acted as an agent of the nation of Egypt, taking several actions or promising to take several official actions that would benefit that country. They say that Menendez also obstructed justice when his lawyers tried to head off an indictment before it happened by lying to prosecutors about some of the underlying facts of the case. And they generally say that Menendez was quite sophisticated and cunning in the way that he acted over several years, never being too obvious or overt in his demands, but always taking money, particularly when his wife Nadine needed it.
What was the strongest evidence the prosecution had against Menendez, in your view?
I thought they did an excellent job of building a circumstantial case that married the timing of various texts, emails, actions, meetings, photographs, with what they say were bribes received by Menendez and official actions or the promise of official actions that he took. So they built three different long summary charts that FBI officials introduced to the jury, and that was their way of bringing in literally hundreds of texts and emails that showed over a 5-year period, this is what Menendez was thinking, this is what Nadine Arslanian, later his wife Nadine Menendez, was thinking, this is what Fred Davies and Will Hanna, who are defendants, were doing, and a whole long list of characters that are also involved in this case in some way.
How much depends on the testimony of the witness who flipped, Jose Uribe?
It depends on who you ask. The prosecutors say that they built a strong, essentially bulletproof case that does not rely heavily on Uribe, who's a former insurance broker from New Jersey who pleaded guilty to bribing Menendez and testified against him for several days. The prosecutors believe that they corroborated his account at every step of the way. On the other hand, Menendez's lawyers say that prosecutors are quite reliant on Uribe, who is a serial liar who fabricated conversations to make Menendez look bad and who can't be trusted, and that because he can't be trusted, the government's case can't be trusted either.
There were some heavy hitters that testified against Menendez, including the New Jersey Attorney General at the time and the top federal prosecutor in New Jersey.
Right. The former New Jersey Attorney General Gurbir Grewal, who's now the enforcement director at the Securities and Exchange Commission, testified about a phone call and a meeting that he had with Menendez in 2019 that prosecutors say, was part of the bribery scheme. Jurors also heard from Philip Selinger, who's the current U.S. Attorney in New Jersey, which makes him the top law enforcement official in the state. And they also heard from an former undersecretary at the U.S. Department of Agriculture about a similar phone call that he took from Menendez, in which he said the senator asked him to drop an effort to get Egypt to abandon a monopoly that one of the defendants had in Egypt for meat inspection under the halal standards.
We've talked before about the physical evidence of those gold bars and the $500,000 in cash. How does the defense explain that?
The defense spent a great deal of time in its summation trying to explain the gold bars and the cash. On the cash, they said that the prosecutors failed to show that there's a connection between that currency that was found in the Menendez house in Englewood Cliffs, New Jersey by the FBI and any actions that he took as a senator. They also say that Menendez had a long-standing habit instilled in him by his Cuban refugee family of taking out cash regularly from his bank account and essentially hoarding it. And that's how they can explain away a great deal of the cash. They also say that the gold bars were given to Nadine, his wife, without his knowledge, and that he had nothing to do with the gold bars. So they have a number of explanations. They also acknowledge that this is a difficult part of the case for the defense. They say that it is really the heart of the government case and that if jurors will be patient and listen to their explanation, that the prosecution's case just falls apart.
David, is their main defense saying that the prosecution hasn't proven things beyond a reasonable doubt, or do they have an affirmative kind of defense?
They say there's an absence of evidence, that they have not proven the case beyond a reasonable doubt. They also say prosecutors failed to show that Menendez either promised to take official action or actually took official action. And they've attacked the way that the prosecutors put the case together using these massive summary charts of texts and emails and phone calls and meetings, saying that they're asking the jury to go too far to draw negative inferences without having direct proof of any wrongdoing.
So Menendez's wife is being tried separately, which is like a gift to Menendez in the case because it allows him to point at someone who's not in the courtroom as a possible culprit. Where does the wife fit in the defense view?
Nadine Menendez is not at the trial because she has breast cancer and is getting treatment for that. The prosecutors see her as a critical go-between who facilitated conversations and bribes between Bob Menendez and the businessmen who bribed him. The defense have used her as a fall person to blame for many of the actions that prosecutors say were criminal, and they essentially say that Nadine held critical information from Bob about the poor state of her finances and the gifts that she received from those businessmen.
I thought it was interesting. At one point, he summoned her with a bell, and the prosecution used that to show that he was the one in charge. Tell us about that bell ringing.
Right. There was a critical meeting on the patio at 10 p.m. on September evening behind the house of the Menendezes, where the businessman who pleaded guilty, Jose Uribe, met with Menendez, and prosecutors say, and Uribe testified, that he gave critical details to Menendez about what he should say to the New Jersey Attorney General at the time, Gurbir Graywall. The two men were sitting on the patio for an hour, according to the testimony, drinking Grand Marnier, smoking cigars, and Menendez needed to write down some information, and this was a colorful part of the trial. According to Uribe, Menendez picked up a bell and rang it to summon his wife, who came out with a piece of paper.
And the prosecution said the bell showed that he was the person in charge, not a puppet having his strings pulled by someone else. You know, we had talked before about whether Menendez would testify or not, and I thought he might to try to counter some of the evidence and perhaps win over a juror or two, get a hung jury. Did the defense mention at all why he didn't testify?
Menendez said outside the courthouse, after he announced he wasn't testifying, that he felt that the prosecutors had not proved their case. So he was essentially saying there was no need for his testimony because they failed to prove beyond a reasonable doubt that he engaged in all this criminal conduct.
He's accused of bribery, extortion, fraud, conspiracy, obstruction of justice, and acting as a foreign agent of Egypt. If he falls on one, will he fall on all of them, or are there unique circumstances for some of those charges?
I think what is going to make this case difficult for the jury to judge is there are a number of separate plots alleged by the government. There's overlapping evidence and intersecting points and players, but this is going to be a difficult job for the jury to weigh all these different criminal charges against three defendants. I think it's going to take them a while to reach a verdict.
There's also 1,300 exhibits?
At least 1,300. There's a lot of evidence to go through. The prosecutors took nearly 6 hours in their initial closing argument. Menendez's lawyer took at least 5 hours. There's a couple more closing arguments, then the prosecutors get a rebuttal case again. And then there's a fairly complex set of legal instructions that the judge has to give to the jury. And this is a jury that was told that the case would last 6 weeks, and now we're almost into our 9th week of the trial.
Well, I know you will be there until the bitter end, David. Thanks so much. That's Bloomberg legal reporter David Voreacos. In other legal news today, Archegos Capital Management founder Bill Hwang was found guilty of criminal charges stemming from his firm's 2021 collapse, concluding a 2-month trial that captivated Wall Street. The jury delivered verdicts against Hwang and his co-defendant, former Archegos CFO Patrick Halligan. Both men were convicted of defrauding Archegos counterparties like Credit Suisse and UBS by lying to them about the firm's trading activity and the level of risk in its portfolio. Hwang was separately found guilty of manipulating several stocks, including the former Viacom CBS, though he was acquitted with regard to one stock. Both men were also convicted of participating in racketeering conspiracy. Each count theoretically carries a maximum sentence of 20 years in prison. The judge set an October 28th sentencing for both men. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.